Every day, billions of people click I agree without reading a single word. But what if you wanted to challenge that agreement later? Could you argue it wasn't a real contract? In 2007, Feldman v. Google answered that question loud and clear, and the answer was bad news for people who skipped the fine print. Background story. In the early 2000s, Google's AdWords program allowed businesses to pay for sponsored search results. Before creating an AdWords account, users had to agree to Google's terms and conditions, a Clickwrap agreement, requiring users to check a box or click a button marked Yes, I agree. Bradley S. Feldman, an attorney, signed up for AdWords in 2003. Later, he disputed charges from Google, claiming he'd been billed for invalid or fraudulent clicks, essentially that people or bots were clicking his ads without genuine interest. Feldman sued Google in a Pennsylvania court for breach of contract, unjust enrichment, and violation of consumer protection laws. Google responded by asking the court to enforce a forum selection clause in its terms, meaning any dispute had to be brought in Santa Clara County, California. Issue. Were Google's Clickwrap terms, including the forum selection clause, legally binding on Feldman even if he claimed he hadn't read them? Rule. Under U.S. contract law, Clickwrap agreements are enforceable if the user has reasonable notice of the terms. The user manifests assent clicking I agree. Courts generally uphold such agreements, unless they're procedurally or substantively unconscionable. Application. Feldman argued he hadn't read the terms in detail. The forum selection clause was unfair. Google argued Feldman, as an attorney, had ample opportunity to read the terms. The Clickwrap process gave clear notice. The terms were available via a conspicuous link before acceptance. By clicking I agree, Feldman consented to all terms, including the forum clause. The U.S. District Court for the Eastern District of Pennsylvania sided with Google. The judge held that failure to read the terms does not excuse compliance. The Clickwrap agreement was clear, and Feldman had reasonable notice. The forum selection clause was valid and enforceable. As a result, the case was dismissed in Pennsylvania and had to be refiled in California if Feldman wished to proceed. Conclusion. Feldman v. Google, Inc., 2007 confirmed that Clickwrap agreements are binding if presented clearly and accepted by the user, even without reading. It reinforced the idea that in the digital world, a click can be as legally significant as a signature. The case serves as a warning. Those terms and conditions aren't just decoration. Clicking I agree is making a promise, one the courts will enforce. If you've ever clicked I agree without reading the fine print, give this video a like and maybe read those terms next time. Subscribe for more landmark digital law cases.